Okay, welcome everybody. We've still got quite a few people registered who will possibly be popping in as we start. But given everyone's time is quite precious, I will kick off. My name is Ren Flannery, and I am a Sector Development Officer leading the human rights work at QCOS. In our team, we do a number of different events and opportunities and resources for the sector. I just want to get started in saying that, sorry, I'll just get my words up here. I just would like to start by acknowledging that we are all on the traditional lands of the Aboriginal and Torres Strait Islander people in the various locations that we are currently living and working. For me, that is Garrambai, which is Rapper Creek in the Northern Territory. Traditionally, this has been known as Larrakia People's Country. However, I've just recently found out that is a coloniser's name, and they are in discussion about which particular name they would like us to use. But one word that has been suggested is Gulumiring, which is one sort of name that is used for the Larrakia people traditionally. This is a very special place, Rapper Creek, Gurumbai. There's a couple of special sacred sites here, and I feel very privileged to live here and to have been brought up on this land during my early years. It's been very formative for me, so I have a lot of respect and gratitude for the traditional custodians of this land, and would like to pay my respect to elders past, present, and all of the emerging leaders amongst my community. And I would like to extend that to the traditional custodians of the land you're on, and also to any Aboriginal and Torres Strait Islander people who are joining us here today. QCOS is in support of a First Nations voice to Parliament, and we understand that there are some, it's been a really challenging conversation for First Nations people, and a very public conversation, and this has had different impacts. So we have a lot of respect to the experiences of First Nations people through this time, and we support the yes vote, and we are committed to doing whatever work we need to be doing post the referendum, no matter what the result is. QCOS will be walking alongside First Nations people either way. Now, for this webinar today, we are looking directly at focusing on defending the rights of children in watchhouses. This has come out of the fact that the recent amendments can be really upsetting for people working in the sector, because it feels like perhaps there's another wall that's gone up in terms of the advocacy and the work that you can do in supporting your young clients. I have come from 18 years experience working in frontline services, initially as a youth worker, youth justice officer, and then in policy and advocacy. So I know very well how disempowering this kind of news can be. And so we wanted to gather today just to have a look at what the amendments are and how they're going to impact children. We also want to look at the work that Yeti's been doing on the ground and how they advocate for the human rights of young people in Far North Queensland. We're going to be talking about advocating for the rights of young people involved in the justice system and different avenues that you can take to do that. We will also look at different avenues of transparency related to the treatment of detention. Lastly, we'll have an overview from the Queensland Human Rights Commission to talk about what is the complaints process and what are some of the avenues you can go down if you have clients who are being impacted by these new amendments. I just want to acknowledge that we were going to have a really amazing First Nations lawyer to be joining us, who is a great advocate in this space. Unfortunately, she's fallen ill quite suddenly, and we were not able to replace her. And I just want to say that QCOS is continuing to work out how we can strengthen our engagement with First Nation communities and making sure that we have a representation of First Nation voices across all the work that we do. And I want to acknowledge that it is not great that we don't have someone here today. So I just wanted to say that in advance. But to move on to our speakers now, I'd like to introduce, we have from the Youth Advocacy Centre, we have Damien Bartholomew, who is a solicitor, and Catherine Hayes, who is a CEO. Genevieve Sinclair, who is the CEO of Yeti, will be speaking today as well. Matilda Alexander, the CEO of Queensland Advocacy for Inclusion, will be speaking today, and Annabelle Newton will be speaking on behalf of the Queensland Human Rights Commission as a manager in complaints. Now, we are going to do quite an extensive Q&A at the end, and we would like to encourage a robust discussion. But because we've had quite a large registrations, we are going to have to manage this to make sure that we're very respectful of each other and make it a safe space for people to speak. So what I'd like you to do is, if you have questions along the way, please put them in the chat. I'm going to copy and paste them into a document, and I'll ask the panel some of these questions at the end. And then any additional time that we have, I'll put it out to the floor to ask questions, but please raise your hand and I'll make sure that I keep an eye out for anyone who has their hand raised, and then I'll hand it to you. All right, I think that's it from me, and I would just like to pass it to our first speaker, who is Catherine Hayes from YAC. Thank you, Catherine.
Thanks, Ren. Thank you very much. And thank you to everyone today for your interest in this topic, because it's something that is a rapidly evolving situation here in Queensland, as we all know. Even today, there's been an announcement that has taken a few of us by surprise, but we'll get into that a bit later. First of all, I think the most recent amendments that overrode the Human Rights Act were the catalyst for them was really the action by the troublemaker in Cairns, Genevieve Sinclair. She brought the action on behalf of Yeti, and it was a well overdue action that was on the basis that the kids were being held unlawfully in the watch house, and the proceedings in the Supreme Court were a very good impetus to get the government thinking about how they can move kids on from the watch house. The first step in their response was these amendments. So previously, the Youth Justice Act said that when a child is ordered by the court to be in the custody of youth justice, the police service must move them on to the Department of Youth Justice's custody as soon as practicable. So that's the term that's important here, as soon as practicable. And the government arguably was not complying with that clause because it was holding the kids in watch houses up to 39 days. So by anyone's measure, 39 days in an adult watch house is not as soon as practicable. And that's the basis upon which Yeti brought its proceedings, saying it was unlawful, just from a very simple perspective. In response to that, the government then changed the Youth Justice Act and other acts, and the effect of it has been that when a child is ordered to be held in custody, the Act now requires that the QPS transfer the child to Youth Justice's custody, so from a watch house to a detention centre. Now, this gets complicated. As soon as practicable, after the date that Youth Justice notifies the QPS that there will be room in the detention centre. And in working out this particular date, Youth Justice is to take into account the number of kids in the watch house, the number of kids in the detention centre, each child's age, sex, cultural background, suicide risk, health, mental health, substance use, cognitive capacity, the impacts on the other kids in the watch house, the impacts on the employees of the QPS in the watch house, the impact on the employees of Youth Justice in the detention centre. So Youth Justice looks at all of these factors, works out a date that the particular child can be transferred to the detention centre, and then the police must transfer the child as soon as reasonably practicable after that date. So that is not at all straightforward, quite complicated. And our view is that that's going to result in longer stays in watch houses and longer stays in conditions that are a breach of these kids' human rights. So in its statement of compatibility of the amending act, which you'll recall was introduced with a flurry of negative publicity because these amendments were part of a very large amending bill, 42 pages long, I think, that contained amendments to a whole range of different acts with different subject matters. For example, the management of a mining town. So this was introduced under subterfuge. And in its statement of compatibility with human rights, the government has conceded that these measures do breach the human rights that are articulated in Queensland's own Human Rights Act and also the United Nations Conventions on the Rights of the Child. So the particular rights are that detention is a last resort, a child's best interests must be protected, a child has a right not to be punished in a cruel or degrading way, a child has a right to privacy and non-interference with their relationships with their families. So in watch houses, the child is often in a cell that has either a glass wall or a glass door and can be observed at all times, so they don't have privacy. When they go to the toilet or to the bathroom, they're observed as well. They don't have the same access rights as in detention centres, so that family relationship is often marred. And Genevieve will probably discuss about how when a child is moved from up north or from Mount Isa down to a watch house in the southeast corner, their family has very little opportunity to maintain any kind of relationship with the child in the watch house, and that's if the watch house has facilities for a child to visit. Across Queensland, the watch houses have very differing conditions. Some watch houses have much better conditions than others. We had clients in the Maroochydore watch house where they have no access to daylight, so they don't see sunshine for days, weeks at a time. There's no outdoor area where they can do their exercise. So those kind of conditions aren't conducive to upholding their human rights. The other rights are the right of Aboriginal and Torres Strait Islander peoples to maintain kinship connections, the humane treatment of when they're deprived of liberty. There's a right, they have a right to be segregated from adult detainees. In many watch houses, they're exposed to adult detainees, and that can often have damaging effects, particularly where young girls are around adult men that behave in an inappropriate way. There is a right to education, and there is some very limited access by education officers in some of the watch houses, but overall the right to education is not being upheld when kids are in the watch houses, and arguably not even when they're in detention centres. There's the right to health services, which isn't occurring at the moment in the watch houses. There's also a right to be held with a rehabilitative aim, and the overarching principle that detention should be a last resort and for the shortest possible time. So they're two fundamental principles which are being breached here, because these amendments are resulting in, we anticipate, longer stays. So that's our concern with the amendments to the Act. Damien, have you seen anything in practice as a result of these amendments?
I guess what we continue to see, of course, is that young people are being held in the watch house for considerably long periods of time. So that is the greatest concern at the moment. Well, I suppose what we haven't seen on the ground is we haven't seen that there has been a declaration made of a particular watch house as a detention centre. But there does, I think that generally what has been a result of this is that the concern that people previously expressing about young people being in watch houses, there is some view that, well, that is now part of the landscape, and that is of particular concern.
Thank you, Damien. And you reminded me of the other amendment that I haven't mentioned yet, which is the power to gazette other places as detention centres. So a watch house or an adult prison can be gazetted as a detention centre. But that is significant because once gazetted as a detention centre, the site must comply with the Charter of Youth Justice Principles, which is in the Youth Justice Act. So that's quite a comprehensive list of standards that a detention centre must meet. Arguably, the detention centres themselves aren't meeting that, but at least if there is a watch house that's gazetted as a detention centre, there are some standards that it needs to meet. There is also a power for a child to be held in a place that Youth Justice or the Director General of Youth Justice determines. So that's a very broad power, and we don't quite know how that's going to be working, but that's something that's in the Youth Justice Act as well. The announcement today of the remand centre is interesting because it hasn't been clear whether it's going to be gazetted as a detention centre, but I presume that the government will have to do so because it's not a watch house. Otherwise, the police would be running it. So it needs to be gazetted as a detention centre, which means it'll have to comply with the Charter of Youth Justice Principles. That hasn't been made clear yet, but the idea is that this remand centre will hold up to 50 young people and will reduce pressure on the watch houses. It's not clear what the impact is going to be over the summer period because it won't be built until for 9 or 10 months. So we still have the summer period to contend with where the watch houses will again be very crowded. So that'll be in the coming months. But that's it from me.
Thank you so much, Catherine and Damien. It's really important to understand what areas of the Human Rights Act that the and other human rights legislation that the amendments are breaching. And I think it's really important to get that picture of what it is like in the watch houses, because so often we don't know. If you haven't been into a watch house, if you hadn't had any experience where you've worked with people in who have been detained in watch houses, then it's actually really challenging to understand what the conditions are like. And so it's really good to have that overview and to understand the impacts that this is having on young people and the way it's breaching their human rights that really shouldn't be happening in a country like Australia. So I want to thank you, Catherine and Damien, for sharing that. And we're going to move to our, and I just, for people who have just entered, if you have questions for Catherine and Damien, please put them in the chat and I will endeavour to ask as many as I practically can at the end of this session. But we'll move to our next speaker, Genevieve Sinclair, who's the CEO of Yeti. And Genevieve's going to talk about some of their work that they do on the ground with children in the watch houses and some of the things that they're seeing and experiencing there. So thank you, Genevieve.
Thanks, Ren, and thanks, Catherine. I just also want to start by acknowledging the traditional owners of the land where I am today, to give my Wallabarri Dingy people and pay my respect to elders past and present. My voice is a bit croaky. I have a cold, so bear with me a bit on this. Thanks, everyone. Thanks, Catherine. It's hard to know where to jump in on this. Yeti, people know we're a little NGO. We're about 50, 60 staff up in Cairns. We're just based in Cairns and we don't go anywhere else. We provide mainly drug and alcohol treatment programs, but also probably half our services funded to deliver youth justice programs. We go into the Cairns Watch House most days in our partnership with YAC. We go to Cleveland Youth Detention Centre once a week and we visit the adult correctional facilities as well. We, for many years, obviously have had some concerns around human rights conditions in both the detention system and in the police watch house system. Catherine mentioned quickly the fact that I won't go into it too much, the habeas corpus, the court case that commenced some of this kind of exposure of what occurs for young people across our state in relation to their detention in watch houses. That case was brought on with Caxton's support and Grata Foundation, a case against Queensland Police and Youth Justice, asking for the immediate transfer of a group of children from watch houses to detention facilities, challenging the legality, the lawfulness of them actually even being able to be detained in those environments. The reason, obviously, that court case came around was because of the conditions that we'd witnessed for some years visiting the watch houses. We go to Cairns Watch House, but the experiences look so different in the regions compared to what's experienced for young people down in the cities. So our watch house in Cairns, I update watch house lists every morning and have for some years now of every kid that goes through the Cairns Watch House. I don't know why it remains in my job, but it's a useful activity, I think, to keep across exactly which young people are in there, how many and for how long every single day. The Cairns Watch House is a very busy watch house. Children are located next to adult prisoners. The girls, for example, are direct hearing from adult women. The cells are only designed to have 2 children in them, if they're designed to have children at all, but 2 young people in them. There's regularly 4. They share mattresses on floors. There is, like Catherine mentioned, no toilet. The toilet just has a half dignity wall. Apparently that's what they're called, across them. The kids report how they build mattresses up around the toilets to be able to use them privately. Kids are in there for up to 29 days we've had in the last 6 months. Young people are regularly in there for 10 days plus at a time. There's obviously, no natural light and access to fresh air. Sometimes the kids can go outside at various points. I think when we brought the case on against government was at probably a point of wit's end of raising our concerns and issues over and over again with the heads of custody statewide, both police and youth justice, around at least trying to standardise access for young people to things like basic reading materials, cards, changes of clothes, access to sanitary items, that should be a standard kind of thing that happens for children that are detained across the state, even if they can't meet, all the human rights needs. There's some basics that should happen, but unfortunately that stuff was very tricky to progress in any kind of comprehensive way. So we were having young people with, no access to their medication, sanitary products, kids coming down from the Cape without a change of clothes for 10 days, despite there being piles of clothes that we would bring in all the time for young people. Hospitalisations of young people associated with injuries in the watch house. Even post the court case, I have to say, which in fact there are some changes obviously that have occurred, but really what's happening on the ground is no different pre-court case and post-court than ever was happening. So the ruling and the changes and the overriding of the Human Rights Act at this point, nothing has changed up here in terms of operation at all, and nothing. It's no worse. It's just no different. It's just kind of been exposed, I guess, a lot more exactly what's going on. Though there is definitely potential, like Catherine was discussing, if they were to use the adult correctional facilities to house children, that would bring up some other ramifications. But basically that's where we got to. Young people were obviously coming out more and more distressed around what was occurring within those conditions. Kids that were visiting were unwell, voicing every day that were visiting that they wanted to be transferred to detention centres, but there were no beds. There's some prioritisation system they used to transfer young people from watch houses to detention centres. Those prioritisation systems they're talking about using now, the same effectively they've always used, but they actually had no kind of there was probably no lawfulness around the way in which the government's been using them. They've kind of just made lawful what they were already doing in practice. Look, I think the bigger problem for us, and one that we'll continually grapple with, obviously as of this morning, we've got young people, 5 in there, kids on breaches of bail and nothing else. Our larger concern up here at the moment is the nature of policing that's meaning that children are ending up in watch houses. There are children in there who could easily be given notices to appear. There are children in there who are there for too long when they could be there for very short periods. Parents are found. The bigger questions we're asking around why, as a state, we've got 150 plus more children in our jails than any other state. It makes little sense to me that Queensland children are not inherently naughtier than children in other states, but there's definitely something around the level of policing that's occurring in our state that I think is deeply problematic. I think today the announcement again put me in a grouchy mood, but remand centres for us, I think what's really critical for us to take on board is the experience for children from the regions looks very different to the use of this remand centre for children in watch houses down south. If this is used to remove children from watch houses in Arakoon, Cairns, Mareeba, Townsville, Isa, it involves flying children to the southeast corner where they have no family contact. Doesn't matter what you do within that space, it cannot be culturally safe. When we've got remanded children held with no contact with their families, or even the logistics of flying children to a southeast remand centre and then flying them back to serve their detention period in Cleveland, the whole thing I think has a lot of unknowns around it. And fundamentally, it's I think what we all really wanted to see was just a reduction in the sheer numbers of young people in detention. If we didn't have so many children in our detention centres, we wouldn't need to use the watch houses at all in this way, and we would have no need for another remand centre. That's probably all I've got to add. I think Catherine covered some of the conditions stuff. That's it.
Thank you so much, Genevieve. And it's really important to hear about what you're seeing on the ground and some of the advocacy work that you've been doing, as you say, around getting medication and essential hygiene products for the kids, and the problems with building a new prison that could remove children from their families and their communities, which is so vital to keep them connected. I think ultimately the bottom line is that, as you say, we need a reduction of children and young people in incarceration. We need to see them being supported back into their communities and their families. That is
Can I say
absolutely
something positive? Sorry, Ren, that I'd forgotten to add because I'm in this grouchy mood around the state government again today. But the really good thing that did happen out of this court case was the relationships that were built. And I know Matilda's going to talk about in a minute what practically some of the exciting things that have come out of this are. But one of them has been the join up between services like ours and other services and the community legal space, like that, working and doing stuff more closely with Sisters Inside and ATSLs and YAC we've always worked with, but that has been a really exciting intersection, is to bring together practitioners who are engaged in youth work in with kind of community advocates and the community legal setting. I'm sure other agencies do lots of work with the community legal centre, but for centres, but for some reason, alcohol and drug services and youth services, we're not that linked that well statewide. So there's been some massive pluses, and Matilda has done some amazing support work for us since that I'm hopeful can be used by other agencies as well. Sorry, I was being very negative.
No, that's great. And yeah, we will. I mean, it's good to sort of look at what are the issues and the reality of what is happening. And now, as you say, we're going to flick over to Matilda, who's going to talk about some of the avenues for advocacy that you can take, and also for transparency with what's going on with your clients if they are in the watch houses. And we just sort of look at some approaches that we can take. So we want to arm you with some tools and perhaps some language that you can use to advocate for your clients. After Matilda's gone through her section as well, we'll just open up to the panel to discuss any other avenues of advocacy that they have used, because we have unfortunately lost one of our speakers who's a lawyer and advocate and was going to speak to some of those. So after Matilda's spoken, we'll come back to the rest of the panel to see if anyone has anything to add. So thank you so much, Matilda.
Thanks for having me, and thanks for those kind words, Jen. I've been asked today to speak about two different processes, the right to information process and OPCAT processes. I've done a lot of work with people in closed environments, so prisons and youth detention centres, including lots of prisons around Queensland and Dondale in the Northern Territory, as well as youth prisons here in Queensland. And I found right to information processes are one of the best ways to ensure accountability. So QAI has a guiding principle that people with liberty have a responsibility to work towards the deinstitutionalisation of others, so we can all enjoy the same liberties and freedoms. And that's a really key thing to my heart. We need to be ensuring that we are looking beyond prison walls, because those places are dark. We cannot see in them unless we look, and what our clients are seeing in them we can't see unless we ask. And there are very clear, very legal ways that we can all ask for that level of transparency and accountability. So the aim of this is to let you know about those means, so that we can all shine a light on what's happening behind bars. As an old saying goes, sunlight makes the best disinfectant. We need to show what's happening behind bars so that we can stop abuse. I'm just going to, I can't share my screen. Ren, can you make it so I can share my screen, please? I'd like to acknowledge.
Are you able to make sure Matilda can share her screen? I thought Maria made a presenter, but maybe not.
Nothing.
And I'd like to acknowledge as well the traditional owners of the land that I'm on today, the Yagara and Turrbal people here in Meanjin. So one of the things I have up on my screen, which you can't see, is a time when 17-year-olds were kept in adult prisons. Prisoners Legal Service obtained some video footage of a 17-year-old placed in a spit mask and left in, and 6 officers in hoods came in like riot gear, came in and restrained him, put the spit mask on him. And we were just able to show, I guess, the start with that story when you tell it verbally, and you kind of get this, oh, here we go, I can share it now, so you can see the contrast between getting an image and telling the story. The story doesn't say much, but when you put this in an image, this was enough to lead. This was the kind of image on the front page of the Courier Mail that led to the end of so you can see very stark here. We obtained as well an image from our youth detention centres, and shockingly their isolation, this was the isolation room in the adult prison for youth. The isolation unit room in the youth prison is worse than this. So there's no, when you look at this room, you can see a toilet, you can see a bench, you can see a bed, you can see a bookcase and a kind of shower. The isolation rooms in Cleveland, and there's 12 of these isolation rooms in Queensland, have a drain in the middle of a concrete floor, no toilet, no shower, no bed, no bookcase, no facilities whatsoever, not even an emergency button that the kids can press if they need assistance, whether it's a medical emergency or if they just need something else additional. So getting those right to information images is incredibly powerful. It can be powerful for, so this is what I'm going to go over, what you can obtain, how to obtain it, timeframes and disposal. It can be incredibly powerful because it means that people are given autonomy back over their own stories that the government is telling about them, and that the institutions that detain them are telling about them. So speaking to a 13-year-old in Dondale, they'd never seen ever. They knew that people came in and wrote reports about them every time, and case noted daily about them. Every hour something was written down about them. They always saw people with their pens out. They never found out what was written about them, and even just getting this and giving this to her was really it developed so much trust and rapport between us, but also made her understand more about what was happening for her and how she could actually get out of the situation she was in. So personal information, this is what you can get through our right to and our right to information laws in Queensland are really good ones. So the federal one is about freedom of information. So this idea, when Queensland made a right to information request, was to reverse that, to say we have the right to our information, not just the government has the freedom to give it, but that it's our right. So you can get any personal information, which is defined as information or an opinion, including whether information or opinion forming part of a database, whether true or not, whether recorded in material form or not, about an individual whose identity is apparent or can reasonably be ascertained from the information or opinion. So what this basically means is anything written down about you, case notes, assessments, reports, file notes, daily schedules, any document with your name, or any CCTV footage with you in it. The Act explicitly says there is a pro-disclosure bias. Which means the government should give it to you unless there is a good reason why not. There are exceptions to this. It's not a complete free-for-all. So they can say if the government doesn't exist, unable to be located, the classic, oh, the CCTV got lost or damaged. And it's the kind of thing that, I mean, even though you can't get the CCTV then, it's really good information to be able to pass on to the Chief Inspector of Prisons, for example, or to another investigative body. If you can say, look, the camera in this room has been broken for a year, or, when the staff are doing extractions, they're not wearing their body cam footage, those kind of things. Another exemption is law enforcement and public safety. So, for example, if you're asking where the weapons cabinet is, you're not going to get that. Security and good order facilities, same kind of thing. If it's contrary to the child's best interests, you won't be able to get that. But again, keep in mind that is something that they have to show. And third-party personal information. And typically this might be where other children, for example, are in the footage. Staff potentially, but with aspects to do with staff, they say personal information relating to routine day-to-day work duties and responsibilities of departmental staff, such as names, positions, and locations, is generally characterised as routine work information with no significant public harm flowing from its release. So, for example, when you're working with youth detention, this might mean you typically will get the first names of the staff members, which is enough to be able to identify them if you're alleging, for example, an assault or a neglect case. Or you want to get further instructions from your client, or talk to the young person about what actually happened. If you can get their case notes and go through it with them, they can identify based on those first names. So there's a form, really quite a simple form to use. It's an online form, but we kind of have a Word document where we've cut and pasted the questions into a Word document that we can print out, because you can't take online things into closed environments usually. An application, a right to information application, can be made for a child by the child's parent or guardian. There is no application fee or processing charges for access to personal information, but there might be access charges. So, for example, if they've got a photocopy 500 pages or something like that, they may charge you for that if they could have otherwise provided it on a disc. You can sometimes inspect I've had requests to see certain footage and they've said, we're not going to give you a copy of that, but you can come to the RTI office in town and view it for yourself. And you have to state if you're making the application for the benefit of another entity. And the example given in the law there is, say, journalist Andrew Bolt is applying for it for Sky News. He can't, if it's for Sky News, he can't use the name Andrew Bolt and to kind of get out of the fact that it's going to Sky News, even though obviously Andrew Bolt's a very famous example. So the processing period is 25 business days, but they ask you for further time, which you can refuse. But you usually wouldn't want to, because usually because they're actually looking for the document, but there may be reasons why you need that urgently. And the decision will often be a mix of things you have access to and things that are refused. And so you can pick it apart and you can appeal it internally, you can appeal it externally. So don't just take their initial letter saying, we're giving you 36 pages of this and refusing 25 pages of that as being the be all and end all. You do have those appeal processes, and any internal appeal has to be lodged within 20 business days. RTI information and personal information is this kind of very much protected. There's a number of different laws, the Public Records Act, for example, the Information Act in Queensland. So there's a number of different laws that protect the information. They can't just get rid of it because you've asked for it. They cannot dispose of any records if they're subject to a right to information request, or have a permanent retention period in a retention and disposal schedule, or are required for legal proceedings. So if you write to them immediately and say, I need this document for right to information, or we're considering action in relation to a restraint that happened, legal action in relation to a restraint that happened yesterday, it falls under this protection, and it can be as well a criminal offence under the Criminal Code, Section 129, for a person to do something to stop it being used in evidence. So, and in my experience, usually the RTI team are separate from the main people who operate these prisons. So they sit in town and they kind of push these through often before the staff have time to realise that that's what you're doing. So it's a very powerful tool. So I've been asked to talk. So yeah, my conclusion around RTI is very powerful, very useful, and there are a lot of complications with then using it in certain jurisdictions, you know, whether or not the person has capacity to consent to the release of it to the media, or whether or not there's other provisions around that. But getting that information, retaining that file, retains that client's rights and gives you time to do the more thorough investigation around whether or not what you can do with it, what the client wants to do with it, and to get further advice. But you don't need to be a lawyer. Any one of us listening can get your client's documents, get your personal information, so that you're right. If you get that footage, you can keep that footage on file for, you know, as long as you want. You don't need to ever use it, but if you do want to use it, you've actually got it. A lot of these retention schedules talk about deleting things after 1 month. That's quite common in the adult prison system for CCTV footage. So it depends on the retention schedule for that particular government agency. But yeah, if you get it, then you can use it later. If you don't get it, it's often lost. So my main takeaway from this is use your RTIs, get your RTIs, right to information, that's RTI, and then later think about how you're going to use them. Don't worry too much about what you're going to do with them. If a client has a query, agrees to getting that information put in the form. Okay, and some agencies may pay for different access requests as well if you do need photocopies and things like that. But usually it's a very cheap process to get the personal information. It's only when you're starting to, you know, RTI, right to information, is also used to get government data. You can ask, like we asked for the number of kids who are being suspended who have disability, and that kind of request usually costs a lot more because it's not about personal information. The other thing I've been asked to speak about today is the optional protocol for the Convention Against Torture. So this is a completely different topic to right to information. This is an international human rights convention against torture, and an optional protocol, which is like the nuts and bolts of how the convention says torture is wrong. The optional protocol provides a way for international monitoring of that. It is related to the Human Rights Act. So these are the 4 things that I'm going to talk about. So the Convention Against Torture says that no one shall be subjected to torture or cruel, inhuman and degrading treatment or punishment. And the optional protocol establishes a system of regular visits by independent international and national bodies to places where people are deprived of their liberty in order to prevent torture or other cruel, inhuman and degrading treatment. Now, for youth detention centres, that national body is the Queensland Ombudsman. They are the Inspectorate of Prisons, and they must visit the youth detention centres once every year. So you can write to them if you think that you've seen an abuse, you think you've seen a room in there that they should be looking at, you think you've seen a practice in there that they should be investigating, who is responsible under the optional protocol for preventing torture, cruel, inhuman and degrading treatment or punishment. So it might be things that you would imagine to be torture, such as physical or sexual harm, including beating or rape. But it could also be things like psychological harm, including prolonged solitary confinement or indefinite detention. And I know the Disability Royal Commission last Friday was released and recommended the prohibition of solitary confinement for young people in detention, as well as the end to indefinite detention of people with disabilities. So the denial of medical or psychological care or disability support, involuntary medical or psychological treatment without regular review, lack of privacy or overcrowding, prolonged isolation, inaccessible, poorly equipped or unhygienic unsanitary facilities. So these are all things that may constitute torture or cruel, inhuman and degrading treatment, depending on a range of different factors. They're kind of things to be alert to. So that's the international law. It does apply to our state law as well. So we have a Human Rights Act in Queensland, which says that a person must not be tortured or treated in a way that is cruel, inhuman or degrading. And this includes not being subjected to medical or scientific treatment unless you give full, free and informed consent. And because Candice is away, I thought I'd stick in a slide saying about the Human Rights Act. You can bring actions under that. So it can either piggyback or combine with another action like a discrimination action or a judicial review or a standalone complaint. So a good one to look at in relation to prisons, a combined action, is the Owen Darcy case, which is a case about solitary confinement in an adult prison where a prisoner was held for upwards of 7 years in solitary confinement. And the court looked at whether or not that was a breach of his human rights and found that that did breach aspects of his human rights, both in the judicial review aspect and in the human rights complaint. So it's a piggyback action. There've also been a separate complaint, a standalone complaint about a prisoner during COVID times and the way that the prisons responded to COVID by locking everybody down for long periods of time. That was a standalone complaint. There are 23 human rights that are protected, but they can be limited if it's considered proportionate. And you have 12 months to bring a complaint. And importantly, under this, there's also a right that the government must also consider human rights and then separately act in accordance with them. So when they moved all the kids to an adult prison in Victoria, they didn't think about the kids' human rights and they lost a judicial review based on human rights there because they hadn't considered the kids' human rights in making that move. Then they kind of did a tick and flick where they ticked some of the rights but hadn't really in depth considered it. And the court still said to them, no, you still haven't considered the rights. You haven't listed all the correct rights and you haven't gone into enough detail. So it's not just a tokenistic thinking about rights, it's a really in-depth consideration of human rights. You've got 12 months to bring a complaint there. So one of the things that happened last year was the UN came to Australia to investigate under the optional protocol for the Convention Against Torture. They sent a team out to investigate Australia, and Queensland, New South Wales didn't let them in to any of the facilities, and Queensland didn't let them into the health and disability, forensic disability facilities. So because of non-cooperation from Australia, the UN suspended and ultimately cancelled their visit. So out of 80 visits of the UN subcommittee for the prevention of torture, they've only had to do that on one other occasion. They'd only had to suspend on 4 other occasions and only had to cancel one other time. I think it might have been Rwanda, but I can't quite recall. So it's a very big embarrassment for Australia. But that didn't, this is about youth detention. That was about health relating detention. So in Queensland, we do have they were allowed to visit youth detention, but they couldn't because the whole visit was cancelled. And we do have an OPCAT body for youth detention. We just don't have it for health or disability. We have produced a number of different resources to help people to understand their rights and to make OPCAT monitoring disability aware. So we've produced these in easy English. So it has some questions like, have you seen sunlight with a picture of the sun? So some kind of trigger questions that we can leave around closed environments or take into closed environments that will trigger whether or not torture or cruel and inhuman degrading treatment may be happening. So you can download those from our website there. Other good OPCAT resources include I've included here. So yeah. And that's the contact details for QAI if you want to get in contact with us. So thank you.
Thank you so much for that, Matilda. I think it's incredibly important for working in the sector to be armed with this knowledge and this language when you are advocating for the rights of the young people that you work with. Genevieve gave a really good example earlier about the way her team advocates for the rights of young people. And if you understand some of the obligations that the government have under these legislations, then you can use that in your toolkit. For example, when I was working in advocacy for an Aboriginal legal service in the Northern Territory, there was an issue where there was no private screening or curtains for the girls in the showers. And, in those times, that's where you can remind the youth justice and the operations team of Don Dale that there are obligations under OPCAT that require them to offer privacy for the young people in detention. And if you have that understanding and that knowledge, then you can use that language in your discussions that you have with other stakeholders, especially government agencies, whom you might be advocating for the rights of the young people that you're working with. So that's why this kind of stuff is really powerful. It's about providing you with knowledge and the language to be able to advocate a bit more strongly for your clients. So we will be providing some of these resources in a post-event email. But in the meantime, as I said earlier, if you have any questions for anyone who's spoken so far, please put them in the chat box. Otherwise, we haven't actually, one of our advocates and lawyers is not able to speak with us today, who would be speaking now. So I'm just going to throw it out to the panel if anyone has any other avenues of advocacy that they think will be helpful, or any examples they'd like to give, if you'd like to do that now before we move on to Annabelle to speak about the complaints process with the QHRC.
Sorry, only a reminder that the Ombudsman at the moment is doing the review in 2 weeks around Cleveland Youth Detention Centre, and I think, is it Woodford or Brisbane? I just know we met, our whole staff team met with them this morning around particularly the issue of segregation and separation within Cleveland. If anybody happens to have any clients involved with those detention systems, that current inspection is commencing. Is that the OPCAT one, Matilda? I get so confused. It is really confusing, this space.
Yeah, the chief inspector is a mechanism under OPCAT.
Okay, so I think this is the first one though that's been into Cleveland.
Yes, yep, first one anywhere. So it was only created last year, earlier this year, possibly even.
And they're going in 2 weeks. So, and I know that they're keen on speaking with agencies who are in that system, working with those young people now.
So even if you don't have teams of advocacy and policy people within your organisation, but you have direct engagement with the young people in these situations, and you have a lot of, voice that you want to give, that you've got a lot of examples, you have a lot of concern, then I think, as Genevieve's saying, team up with other organisations so you can support reviews or any policy submissions that other organisations may be putting in, and a lot of the peak bodies will do that, so that you can contribute your voice to what you're seeing on the ground. That's really important. It's really valuable information. QCOS will often do policy submissions around a number of different areas, and we're definitely keen to hear from the voices of our members about what are their concerns and what are they seeing on the ground. I just want to mention too, also Matilda mentioned the right to information. She spoke to that quite a lot, and shining the light on what is happening in places of detention is really important and is very valuable. And again, I'm coming from a position where I have more recently worked in the NT, and we have seen how exposing what's happening in places like Don Dale has had a great importance to the advocacy that people have been able to do on the ground, because now the community knows, now the community has seen the reality of what's happening, and that again is a really powerful tool in our advocacy. So just knowing that you can use the RTI, knowing that you can use the language in your support for the young people, I think is really important. Did anyone have anything else they want to add in terms of different avenues for advocacy before we move on to Annabelle? Okay, great. I'm going to pass to Annabelle Newton now, who is here with us from the Queensland Human Rights Commission. And Annabelle is going to speak to the complaints process. So earlier on, if you can reflect back to Catherine speaking about the different areas of the Human Rights Act that may be in breach for these young people. So there are a number of areas that when they made the amendments, they haven't suspended things like right to education, rights to health accesses, some very basic human rights that everybody should be able to access. And some of those rights are going to be limited under these new amendments, and we will definitely start seeing the impacts of that, and probably already have. So Annabelle's going to talk about one of the processes you can take if you feel that one of your clients has had their human rights breached under the Human Rights Act of Queensland. Thank you, Annabelle.
Thank you. So I would also like to start by acknowledging the traditional custodians of the land on which I'm on, which is the Turrbal and Yagara people. And just say thank you to all of the panel members who've outlined everything so that this makes more sense. So in terms of our process, you're right, Ren, as you've acknowledged, there are some things that the Commission can't deal with. So following the 23rd of August, places such as watchhouses that are declared to be detention centres after that date, and human rights obligations don't apply to children in those settings. As we know, that hasn't happened as yet. However, obligations under the Anti-Discrimination Act continue to apply. And in terms of human rights complaints that we are dealing with and can continue to deal with, conditions of detention in a watchhouse. So along the list of relevant rights, keeping in mind conditions before a regulation has declared the watchhouse as a detention centre, treatment of a child during transport to a detention centre, acts and decisions that affect a child detained in a place that became a detention centre after 23rd, if the act or decision is not reasonably necessary for the administration of the Youth Justices Act. So, for example, mistreatment of a child in the detention centre. When we're deciding whether to accept a human rights complaint in this category, the Commission's general approach is that the entity that did the act or made the decision is responsible for establishing that it was reasonably necessary for the administration of the Youth Justice Act. From a practical perspective, in terms of, and sorry, some of that information or all of that information, we do have a fact sheet. Ren, human rights complaints by children in detention. In terms of our actual complaints process, if you, as an advocate, have identified that your clients, one of these young people, that their rights have been, on the face of it, unreasonably limited, you can lodge a complaint with us immediately. But you do need to make that internal complaint first, but you can do it at the same time. So under the Human Rights Act, you need to make an internal complaint first to the public entity, then you wait for, and then we usually require that you wait the 45 business days before we can conciliate or we can deal with the complaint, but it can be waived in particular circumstances, and all the circumstances that we've been talking about today would be reasonable circumstances when that 45-day time frame can be waived. So from a practical perspective, what we can then do is under the Human Rights Act, under Section 68, we can begin to make preliminary inquiries. And from a practical perspective, what that can mean is relief, at least, with some of these more immediate things. So access to clothes, change of clothes, particular things that are happening within the detention centre that are immediate. There is some avenue for, at least in our experience, we can contact the public entity, reference the complaint that's already been made, the internal complaint, waive the 45 days, and see if there can be some problem solving in that circumstance. And again, just back to complaints of discrimination and other conduct that is unlawful under the Anti-Discrimination Act, for example, sexual harassment, victimisation, vilification, in managing, running, supervising or administering a place of detention, which includes a watch house or police holding cell, those complaints can still be made. So, of course, there are complaints under the Human Rights Act. And as I said, first thing is there needs to be an internal complaint, 45-day time frame usually we wait for before we start conciliating, or we can waive that 45-day time frame and try and problem solve beforehand. But also, if the complaint is, as Matilda was talking about, a piggyback, so if there are discrimination elements, so unfavourable treatment based on protected attributes, and we're talking about a very vulnerable class of people, relevant attributes could obviously be age, but you've also got race, you've got disability, gender, all of these things. There are maybe circumstances where you can bring an ADA complaint as well. So to be clear, complaints that the Commission cannot deal with are decisions affecting the length of time that a child is detained in a watch house after the 23rd of August, decisions to transfer a child in custody to another watch house or other specified place, for example, a holding cell of a police station, acts and decisions that affect a child detained in a place that became a detention centre after 23 August, if the act or decision is reasonably necessary for the administration of the Youth Justice Act. So to be clear, any acts that are clearly not necessary for the administration of the Youth Justice Act can still have a human rights complaint made to the Commission. So, so I don't know if any of the panel have any questions or comments that they want to make about our actual complaints process in terms of how we resolve complaints. So again, for a human rights complaint, pure human rights complaint, the first hurdle, or not the first hurdle, but the first obligation is you make the complaint to the Commission, ensure that complaint form or whatever format you've submitted it in, hopefully the complaint form that we've got, notes when the internal complaint was made, and then whether or not you're asking the Commission to waive the 45-day timeframe, or if that 45-day has lapsed. So if you have given an opportunity to the public entity to resolve it, obviously let us know if that's happened as well, or if it's happening concurrently. And then, if obviously it's important to let us know or to flag that it is urgent if you need it to be dealt with as soon as possible, which is pretty much every complaint in this category.
Annabelle, I get confused, and we're somehow involved in the human rights case with Capstan that's sitting at QCAT at the moment, like exploring the conditions of young people for their experiences in the watch house.
Yeah.
That case commenced 18 months ago, and I know that's a QCAT issue. So the Human Rights Commission can just deal with immediate kind of human rights things, not the underlying conditions, because it's not like there's no work that we've done as advocate agencies in this space. It's the time delay of 18 months since that was lodged with QCAT.
Yeah, sorry, Genevieve, I probably made that sound a lot more straightforward than it actually is. What I meant, and what I should have said at the beginning, and I should clarify that the Commission has had a large volume of complaints that we've been getting through, but most of that we've gotten through now. So nowadays, if you lodge a complaint, we will deal with it in a fairly quick time frame.
This is not you dealing with it, this is QCAT.
No, yes, I acknowledge that. Sorry, but when I was talking about, and we could like make preliminary inquiries and this sort of thing, what I meant was actually just from a practical perspective, using the complaints process as a tool. So in some circumstances, and I know it is not in all, and it is not going to happen every time, but in some circumstances, lodging that complaint to the Commission, outlining graphically what is happening for a particular individual can sometimes mean that the public entity who's receiving that complaint problem solves it. And like I said, so this isn't, I'm not talking about systemic releasing everybody, changing conditions for everyone, but things like not accessing clothes, things like not being fed, things like being, like there may be circumstances where they use that opportunity to fix the immediate problem. But does that make sense? I'm not sure if I articulated that in a way that was helpful.
Yeah, so it can fix the immediate problem, but it doesn't stop that happening again to another.
That's right.
It's case by case, individual.
Yeah, and I suppose that's the thing to highlight, as one of my colleagues very kindly highlighted, is ours is a dispute resolution process. QCAT is a decision-making framework, and that is very different. So because we are impartial, we're neutral, we don't make determinations. That's not our role, certainly under the ADA, but so too from the Human Rights Act. We don't say, well, we accept a complaint if we see that there's been a breach. It's up to the respondent entity in certain circumstances, as we said, like with the Youth Justice Act. If they're saying we would accept a complaint, it would be up to the respondent to argue that whatever thing you're complaining about was reasonably necessary for the administration of the Youth Justice Act. But that would be perhaps part of a discussion or a conciliation. That wouldn't necessarily be a barrier to us accepting a complaint. So using our process, I would say that advocates could use the complaints process as part of a problem-solving strategy. Use it as a tool.
Thank you so much. I just know coming into this, it's really confusing for ages. It was confusing for us 2 years ago when we started this. And so I recommend everyone talking to YAC and QAI before they do anything.
Yeah.
Thank you, Annabelle. And I think what's really important to highlight is that, as Annabelle pointed out, it is a mediation process. It is not one where the result will be compensation, and there can be, it is a process, so it takes time. But the thing with understanding the complaints process itself is you know what's available to you, and you know what's available to your clients. And again, these are things that you can have in your tool belt to use in the conversations that you have and in the advocacy that you do for your clients. You may not ever put in a complaint, but knowing that it's there and understanding the process and understanding why it exists is really helpful when you're advocating for your clients on the ground. I've always found that understanding all these different processes and what the rights of my clients are under different legislation just gives me a language to speak to when I'm speaking to government agencies and when I am trying to advocate for, some basic essential human rights. You can just really gently remind them repetitively that these are obligations that they have under their own legislation or under international obligations and legislation. So understanding these things just make you more empowered to advocate for your clients and to support the young people. It also, you can help use a young person's language to discuss with your clients what their rights are and what are some of the processes that can be taken to support their rights as well, which I think is really important when you're developing those relationships with young people that you work with if you are in a frontline position. So we've got one question here from Pauline Coffey, who is asking about young people in the Brisbane watchhouses. And she's heard that the Education Department head of curriculum is responsible and about the Queensland Education responsibilities and their staff to also notice and report and partner with legal peaks. Does anyone know about that information? What are the responsibilities of the Department of Education in regards to the children in the watchhouses? I hope I've got that right, Pauline.
I can't advise what are the responsibilities of Education Queensland, except to say, of course, young people should have a right to education under the Charter and indeed under the Human Rights Act. So we've got to consider those issues as still applicable. And I think what Pauline's asking about is that there is a head of curriculum for the watch house, and I think that is related in particular to the notion that the government has announced a watch house facility at Caboolture, and in relation to that, the government has been very keen to ensure that there are some education facilities that are available to those young people, but that facility hasn't opened as yet. I'm not privy to exactly what the responsibilities are, but what I also do know is that currently no young person in the detention centre is currently getting access to really anything that looks like an education. And indeed, it's hard enough for young people who are actually in the detention centres to be accessing the school and education facilities that are actually on offer there due to the significant periods of lockdown that young people are experiencing. Genevieve will be more familiar with that because that's more acute in Cleveland than it is in Brisbane or in Westmoreton.
And it's also an obligation under Section 12 of the Education Standards Act to provide education. And RTIs, again, come in really handy. You can RTI the Department of Education to find out exactly what education has been delivered to a person in a particular period of time. So you could do that for the period of time they're in youth detention or the period of time that they're in with the watch houses.
Matilda, can I be a giant nuisance on that? It is a struggle, though. We were talking to the Ombudsman today around this very issue of what education is, because despite Cleveland employing 70 Department of Education staff, there hasn't been classrooms running there for most young people for 4 years. And children are delivered an education pack under their door frequently when they're in night mode in lockdown 23, 24 hours for extended periods of time. And education is said to be school, that pack under a door. So there is definitely some ways in which school is being interpreted by.
There is, And if all we have is anecdotal stories of getting a pack under a door, it's not going to add up. But if we actually have the case files from Department of Education of the kids who, they'll have to note that that pack is being delivered, we'll be able to concretely show what education is and isn't being delivered and show that it's inappropriate. So some of the litigation coming out of Banksia Hill.
Will the Ombudsman gather that at the moment in the course of the investigations?
Not unless we ask them to. So that's the kind of thing that you can ask the Ombudsman. If you're alert to something, ask the Ombudsman. They have the power to investigate all those records. And in the Banksia, that was part of the Banksia Hill litigation that they've got in the federal court at the moment. You can read that Banksia Hill case. All of those documents are currently listed. The pleadings are listed on the federal court for any geeky lawyers who'd love to read other cases pleadings. And part of that is that the education is being offered in a way that is not accessible to kids with disability in Banksia Hill. So that's part of the current federal court action.
Okay, if we have any other questions, if you'd like to just raise your hand. Catherine.
Thanks. I've got a question for Matilda. Matilda, can we RTI either the courts or YJ to try to find, I really am trying to work out how many cases are being dismissed because cautions should have been issued to children by the police. There's an obligation, the courts are dismissing a number of them. I just want to know what that number is. Can we RTI?
Yep, that would be the kind of information that they collect, and they could collate. There would be probably a fee attached to that because it's not personal information.
Yeah.
But yeah, that would be the kind of thing you can get through that other part of right to information, which is about, a government, how well government is working more generally.
Great. Okay. So that'll be the courts we'd do.
Mm-hmm.
Okay.
Yeah.
Thank you.
DJ.
Thank you.
Any other questions? Been a lot to take on. I have one final question for the panel if no one else has questions. Genevieve, you mentioned earlier about the importance of collaborating with legal and advocacy services, and having come from working with legal services, but prior to that working in direct frontline community service provision. I do agree that those collaborations don't happen too often, and they are really important because the community services on the ground don't often have the resources to do the advocacy work and to do the policy work and to have the understanding of the legislation. But if you work together, then you can provide that voice to the advocacy bodies and the legal services. So could you just, if the panel, especially Genevieve, if you would like to speak to the importance of those collaborations and how you've gone about setting them up so that others might be able to do the same thing with services in their area or across the whole state as well.
Yeah, I think it is super confusing because obviously as community workers, many of our staff in here are seeing things that that are obviously unjust, that are breaching people's human rights and particularly children's, and it's distressing as a worker to go through that and try and find pathways to advocate when you keep hitting those walls. I think the big thing for us was the conversations with the human. I mean, I called the Human Rights Commission 2 or 3 years ago at points of frustration around segregation in Cleveland. Not originally around watch houses, it's the relationships with Caxton and the new ones, excitingly, with QAI. YAC we've worked with for a long time, but I think it's really using those relationships with other services. And I think the really good work we can do as community agencies is that we know those young people really well. And so when we've needed to get young people up to, challenge human rights things or get the young people to sign up for the habeas action, the Supreme Court action that YAC and Candice, who's supposed to be talking today from YFS, from Logan, from the legal service down there, were involved in finding children and young people to help support that case. It's joining up that bit between our direct work with the advocates and our peaks around that kind of broader systems work. But I think the really important thing is how good it is for practitioners, like my staff, knowing that something's happening for these children when they're seeing these terrible things occurring is really important. And then Matilda's killer training the other day, the fact that we can do our first RTIs and that we can get CCTV footage of what's happening in watch houses, and whether children choose to use it or not is not the critical thing at the moment. The fact that we can have that evidence sitting on their case files, that if they want to use it in the future, that they can use it to understand their experiences or to take legal action, because whatever's happening within the watch houses, and I think particularly what's occurred in Cleveland, we'd be lucky not to have a royal commission around it, but it's some really, really horrific kinds of impacts on children at the centre of things. The lockdowns for months are obviously really deeply harming to children. So yeah, I think it's good for practitioners, and it's really good for us as direct service agencies to engage in this level. But it's confusing. I'm still confused eternally and have to ask people questions every day.
Would anyone from YAC or from Qt AI like to speak to that question in regards to the importance of those relationships and the support that they can give one another?
I just really think, yeah, a holistic approach to clients where lawyers and advocates and youth advocates, disability advocates work together. It's kind of dream of the CLC model, and I think that it works really well. So yeah, reach out and get in contact if you are doing this stuff, and it's much better. It's much easier for the government if they can divide us, and it's much stronger for us if we can approach together.
Yeah, I agree with Matilda and Jen. It's been great working with the other organisations. We learn so much from each other, and at the very least, we can give each other a morale boost when things are bad.
Hey, are there any more questions from anyone today? I'm hoping that everyone's just absorbing all this information like a sponge, because it's been a lot to take on, but we will provide a number of resources in the post-event email, which I encourage you to engage with, because I think the bottom line from today is knowledge is power. It's empowering for you, it's empowering for your clients. So as much knowledge as you can gain for yourself, you will be able to feel more empowered in your advocacy, and that really is helpful for your own well-being as well. As Genevieve said, the work for frontline workers is very taxing. It is very hard on your well-being, and it's important that you feel like that you're achieving something. And I think sometimes the more knowledge you have under your tool belt and the language that you have to be able to do your work really does help with your own well-being as well, because you actually feel like you're moving forward rather than hitting the walls that constantly seem to go up around us. I just want to thank the speakers for today. They've done an amazing job. Everyone's so extremely busy and everyone's jumped on board very last minute, so I'm incredibly appreciative of the efforts that have gone to putting together today. Before everybody runs away, Michael's going to put up a poll. This really helps us with our continuous improvement and to make sure that we're creating events that are supportive of the sector. I also just want to remind you that we have the Raise the Age campaign, and we really would love it if you could join the Raise the Age contact list so that you can be aware of the work that we are doing in this space. Oh, Andrew's already put it up for me. Excellent. Thank you, Andrew. Andrew is our wonderful Raise the Age campaigner, and we're doing quite a lot of work in this area. And the bottom line is we need to get kids out of prison. We don't need to build more prisons. We need to get them out of prison. So really engage with that work. It's so important. Also, if you'd like to hear about more of our events and opportunities, there's a quarterly newsletter that comes out for human rights specifically, and this will give you a whole range of resources, activities, opportunities, professional development that you would like to engage in. All of those things are also on our website, but the newsletter is a really nice kind of quarterly little package that you can receive in your email. The next webinar that we have coming up under our Human Rights in Action suite is going to be Understanding the Parents' Rights in Child Protection System with the Family Inclusion Network, who will be running that. So on Tuesday, the 28th of November at 10:30 a.m. And I'm just going to pop a link as well in chat for that one. Okay. And it looks like we might actually finish a little bit early. So I really want to thank everybody for coming today. This conversation is one that needs to be ongoing. And as I said, please do engage with the resources that we send you. And if you have any questions, please just send us an email and we will try and see if we can answer your questions. But also send us any feedback for more information you'd like to receive around this area or anything related to human rights. And the sector development team will try and address those concerns for the sector as best we can. So thank you very much, everybody, and I hope you have a wonderful afternoon.